Good afternoon. Thank you so much for joining us this afternoon at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School as we have a conversation called The Stories Behind the Sentence, Sentencing Reforms for a More Just Future. We're really excited to have an all-star group of thinkers and reformers and implementers of sentencing reform, both retrospectively and then learning from it prospectively, and in addition, the voice of an exoneree who can give us a real world understanding of what the impact of those policies really can be. So while our panelists are unmuting and coming onto the screen, I'd like to just give a couple of minutes of brief introduction, then we'll let our panelists speak. We do have the question and answer option open and available to anybody who's watching on the Zoom, so please put those questions in. We will answer as many of them as we can. This is a somewhat unique thing for the Quattrone Center. As those of you who follow us know, we take a systems approach to the prevention of error in the criminal justice system, and we really got started in the wrongful convictions realm. And so a lot of the errors that we're trying to solve are pre-adjudication errors that happen so that we can avoid an inaccuracy of guilt or innocence. But if you think about the criminal justice system as a whole, the point of the system is to identify people who have committed crimes, adjudicate those crimes accurately within the rules of the Constitution and local laws, and then do something useful with that person that's going to reduce crime. And if the criminal justice system's purpose is not to reduce crime, it seems like it's sort of a missed opportunity at a minimum. And so while normally at the Quattrone Center we talk about get the right guy in the right way, today we're really going to be focusing on and do something useful to reduce crime. And the people that are here today are pioneers in looking at that part of the system and asking the question, are we really doing it in ways that are useful? How can we make the system more useful? Can we make it safer and less punitive? Can we make it more utilitarian and restore communities that we've damaged? How do we do this better? And so I'm going to just briefly introduce our panelists. I'm going to let them then speak for a few minutes about how they engage in this system, and then we'll see where the conversation takes us. So starting first with Ronald Simpson Bay, a national leader in the movement to decarcerate America. Ronald spent 27 years in prison in Michigan for a crime he didn't commit. He's now the executive vice president for Just Leadership USA and an alumni of their 2015 Leading with Conviction Fellowship. He's a contributing author to the book Smart Decarceration: Achieving Criminal Justice Transformation in the 21st Century. He serves as a vice chair and special advisor for the ABA Criminal Justice Section, and he's on the boards of and founder of several anti-mass incarceration and legal defense nonprofits. And Ronald, it's an honor to have you with us. Turning next to Hillary Blount. Hillary is the founder and executive director of For the People, the national nonprofit that works with prosecutors to safely bring people home from prison. Hillary and her team drafted and secured in 2018 the passage of AB 2942, the first prosecutor-initiated resentencing law in the country. She's a former prosecutor for the San Francisco District Attorney's Office and a fierce advocate for victims of crime, having spent years focusing on crimes against women and children and securing enhanced and stable resources for those victims. And she's the recipient of Fast Company's 2022 World Changing Ideas Award for her innovations in criminal justice, which is pretty impressive. I've never gotten an award for a world-changing idea. So, Hillary, it's great to have you with us. Thank you. John Choi was elected in 2010 and sworn in as the first Korean-American chief prosecutor in the country in 2011. He's a county attorney in Minnesota, a state and national leader in progressive justice reform, working with public officials and impacted communities to reimagine justice and the role of prosecutors in providing that justice. He's helped to transform the way government in Minnesota and around the country responds to domestic violence, sex trafficking, and sexual assaults, and has improved supports for victims and survivors. and has expanded the role of the prosecutor, importantly, in mitigating collateral consequences, including facilitating sealing records for those who've been successfully rehabilitated, reviewing past convictions and sentences to ensure integrity, and better responding to youth who are referred to the legal system by the engagement of impacted communities in reviewing those cases collaboratively and responding restoratively to address the true underlying needs and harm that has been caused to victims and communities. John, I could talk about the list of commission and boards and awards that you've won, but we'd run out of time. So I'm just going to say there's a lot of them, and thank you again for being here. And last, but certainly not least, we have the Honorable Stephanie Sawyer. Judge Sawyer, you mentioned in your bio that you were born in Queens, but you spent all your life in Philadelphia. We have it to shout out as there are a number of Quattrone Center personnel who went to the Philadelphia School for Girls. And so you've been a lifelong Philadelphian, go Birds. After working as an assistant city solicitor and a 20-year career as a sole practitioner, you ascended to the bench, first with the municipal court in Philadelphia, and now where you are in your current position with the Court of Common Pleas in the Criminal Trial Division of the First Judicial District in Philadelphia. And you really bring all of that real-world experience of representing clients and of living in the communities that you serve to your work on the bench. Judge Sawyer has, throughout her career, been dedicated to giving back to the community and ensuring social equity in the law, in part by providing free legal seminars to community and church-based organizations. And since ascending to the bench in 2014, she has been designing, implementing, and always improving her resource-based sentencing and supervision, a form of restorative justice that connects defendants with nonprofit organizations and social services in a purposeful manner designed to reduce recidivism. So obviously, for those of you listening, we've got really a star-studded and very thoughtful and well-informed panel. I do have one other administrative obligation before we get started. There are 2 moments where I have to interrupt the conversation to provide codes for CLE purposes. The first word for CLE purpose is the word improving. And with that said, Ronald, why don't I ask you to kick us off, and maybe you could spend 5 or 7 minutes or so and kind of tell us your story and the inequities of the sentencing that was applied to you as a way of helping us understand kind of some of the problems that Hillary, John, and Judge Sawyer have been working to improve.
Thank you, John. Thank you for that introduction. And I'd like to first thank the Quattrone Center at the Penn State Law School for this invitation and to be part of this powerful panel with these esteemed, illustrious guests. I can say I'm Ronald Simpson Bay, serving as the Executive Vice President for Just Leadership USA, a strategic partnerships. And my backstory is I'm originally from Michigan. I served 27 years in the Michigan Department of Correction. And John, just to kind of correct what you said I was an exoneree. I want to make sure I clarify that because that's kind of a technical term. My sentence was overturned after 27 years, but I took a plea bargain to time served because I felt that at that time, the point of diminished returns was way past, and just a change. I mean, a change in the title just wasn't, worth the effort. So
I'll revise my comments to a crime you didn't commit. And
there you go. Thank you.
Thank you for being precise.
Thank you. So a little bit about my story as far as that goes. Like I said, my conviction was overturned. It actually was overturned in 2009 after 24 years by the federal courts. I had a state conviction in Michigan. And of course, the state appealed it. And so the Sixth Circuit issued a stay, Federal Circuit Court issued a stay on my release on the term of conviction. So I spent 3 more years in prison before the Sixth Circuit stepped in and say either grant him a new trial or release him. And so I was in prison for 3 more years without a conviction before I was even released. And my conviction was overturned on the grounds of prosecutorial misconduct. So dealing with the issues around prosecutors have been a personal issue of mine, kind of now at this point, a lifelong issue because it impacted my life so much. And it's not that I'm bitter about it, but I just don't want to see anybody else have to go through these same types of injustices just to get justice. And earlier, John, you mentioned about, convictions and trials being run under the realm of the Constitution and the laws, but the problem is the application of the Constitution and the laws is applied differently across this country, as we well know. We know that poor people and black and brown people without resources are at the lower end of the totem pole when it comes to justice or injustice. And so we don't see the same equitable application of the Constitution and the laws. And that results in these crazy sentences and things, injustices that go on in our communities, in our prison system. We currently at University of Michigan at their Innocence Project since 1989, over 3,200 people have been exonerated. And that's just the people that actually exonerated, not people like myself that convictions were overturned and they were subsequently released because they took a plea bargain. So there's thousands and thousands of people in this country who have wrongful convictions, and there's no resources for them. You know, if you convicted and you get out and get released on parole, you have reentry services available to you. If you get released because you're not exoneree or your conviction's overturned, there's no resources, and they just release you to the community. And for me personally, to add insult to injury, Michigan didn't have compensation laws at the time. So when I was released after 27 years, I just got a handshake, said, oops, our mistake, and good luck with your life. So I became definitely an advocate around criminal justice reform in Michigan, and I participated in the campaign to get compensation for people with wrongful convictions. And in 2016, we were successful with that campaign, and they enacted a law to provide $50,000 a year for every year of wrongful conviction. And as luck would have it, they didn't make it retroactive, so I didn't get a dime. But I'm glad to be out here in this fight and be champion for this cause and other causes around criminal justice reform.
Thank you, and we really appreciate your telling us your story. We actually did a symposium and a webinar about a month ago on the compensation topic. That can be found on our YouTube channel if anybody's interested. Pennsylvania, and Judge Sawyer, you and I are going to have to do something about this. It's one of the very few states, one of the 12, I think, states that do not have compensation yet. But the idea that it was not retroactive, Ronald, is hard to swallow. Hillary, why don't we turn to you? Tell us about your work with For the People and your experience as a prosecutor, how it led you to become this national advocate for prosecutor-driven sentencing reform, and what that means and what the power of that is.
You know, it's really kind of incredible. I was just reflecting as I was hearing Ronald's story that, you know, our work is actually born out of a symposium that I attended at the Quattrone Center several years ago that was centered on the role of the prosecutor in conviction integrity. And yeah, I was a prosecutor for a number of years, and I really considered myself to be trying to achieve justice and trying to be fair. And what I realized is that I never really considered what happened after a person was sentenced, and this notion that they would be sentenced and then something at this other institution, the Department of Corrections, would ensure that the sentences were just and that people would be released if they were, you know, if they were innocent, there was something, a mechanism in place, or if they had been rehabilitated, there was a mechanism in place. And so my first introduction was really looking at conviction integrity units, and in conversations with prosecutors across the country, asking them about what it would look like to expand these notions of justice. And what we heard repeatedly was, we want to expand into something beyond innocence and into due process, for instance, but we also have all these cases of people that they're not alleging that they didn't commit the crime, but the sentence is so completely outdated and it's so excessive on its face that it does fall under the umbrella of an unjust sentence. So it's an interesting full circle moment, because that really was the beginning of this journey to try to figure out, well, what is the role of prosecutors, and how many prosecutors were similarly situated where they hadn't been looking back and they hadn't been thinking about what happens after a person is sent away. And so this began as a conversation with a lot of prosecutors here. I'm from California, and just this notion that judges don't want cases coming back to them because of floodgates, and prosecutors don't want to be involved in reform, and victims are going to hate any kind of, returning to a prior sentence. And in conversations with crime survivors and with judges and with prosecutors, that just wasn't true. And so that really sparked the idea about trying to devise some kind of law that would allow prosecutors to be able to look back, that would give the opportunity for victims to be included and consulted and engaged in these kinds of conversations. And so that was basically the impetus behind prosecutor-initiated resentencing. So the law itself is it's pretty simple, but it's quite profound, that even in the beginning of this work, I assumed that because prosecutors have so much power in every single step of the criminal justice system, that there was a law that would allow them to go back to the court, go back to somebody like Judge Sawyer and say, I asked for this long sentence and now I've reevaluated and I'm seeking a lower sentence. So in looking through the penal code, surprise, surprise, there was nothing there. There was no mechanism. So that was pretty shocking to me. And so we worked on passing this first law here in California. It gives prosecutors the ability to go back to court and say to a judge, we reevaluated this case. This person did commit the crime, but we've realized a couple of things. One, that this person is serving a sentence that's completely outdated. Nobody under today's sentencing practices would receive a sentence like this. And two, while perhaps the sentence at the time, or maybe it's consistent with what we would do today, this person is in a place of diminishing returns, right? They have already rehabilitated. They've taken every course. They have family waiting for them to come home. They could be a better resource in their community than to be wasting away, languishing in prison. Oh, and we're spending $110,000 a year to house people unnecessarily when they could be paying taxes, right? Walking kids to school and so forth. So, in the beginning, people thought this was a crazy idea. How are you going to get the prosecutor puts people in prison. Now you want to have the prosecutor get people out. Because all stakeholders, victims, judges, prosecutors, they're not a monolith. They don't all think the same. We were able to make a lot of progress here in California and working with progressive prosecutors, conservative, moderate, really just prosecutors that are interested in new innovations and ways to correct some of the injustices of the past, and also incorporate what we now know about adolescent brain development, what we now know about more programming in prisons, thankfully, to help people to accelerate their rehabilitation. So we're really pleased that now the law passed in 2018, went into effect in 2019. And it's been replicated now in several states across the country. There's about 35 offices across the country where prosecutors are advancing cases. They're working with the defense, they're working with judges, they're working with community-based organizations to address the excessive sentence and what, as I mentioned, is an unjust sentence if a person is in prison a day longer than they need for that public safety, the notions of public safety. If they can be safely released, they need to come home. So this movement has taken off and we're, so pleased. And one of the things that I think the judge will agree with is that there's been many judges that over the years, a lot of the discretion has been taken away from the court in looking at different mitigating circumstances. And so thankfully over time, a lot of that discretion has been vested back with the court. And so now with these laws that allow cases to come back, judges are able to use a broader sort of set of tools to make these kinds of evaluations. And so we hear time and time again that judges they're actually sitting in a resentencing hearing on somebody that they sentenced 15 years ago, and they're so pleased to see all of the strides of rehabilitation and that they get to participate in giving this extraordinary second chance to people. So that's what we've been up to over the last couple of years, and it's taking shape really nicely across the country, and we're really, really pleased that prosecutors are in the continuum of looking back, are really being able to embrace that mistakes were made, injustices happen, and prosecutors have to be a part of that redress for things in the criminal justice system.
Yeah, thanks, Hillary. And I think, just the fact that you're involving the prosecutor and the state in that process gives it a certain amount of credibility to the general public. I mean, I think people might reasonably look at this and think, how do you know that you're not going to see a reduction in safety? How does this really work? And your point about the kind of common view of the prosecutor's role. And I think you're really changing that and updating that in useful ways. And by having prosecutors lead that process, it really does imbue it with a sense of credibility and thoughtfulness about the community as a whole, in addition to hopefully reducing some of the punitive kind of dehumanizing nature of sentencing and making it more thoughtful and rehabilitative. So I'm really impressed by that. We did get a question while you were talking, Hillary, about asking for the name of the law. I think I had said that it was AB 2942, but I don't know if that's how it's commonly known or if there was another name or something.
That's how it's commonly known in California. And I will drop in the chat a link to our website that has a breakdown of the laws in different states. So for viewers in the states where the law has been passed, but also to keep in mind that there are other alternative mechanisms that exist in other parts of the state. So it may not be a prosecutor-initiated resentencing law or PIR law, but there are other mechanisms that prosecutors are using to bring cases back to court and work with judges and work with the defense on addressing excessive sentences.
Thank you. So, Judge Sawyer, we've heard from Hillary about how prosecutors can look back and say, hey, we don't, 20 years ago we might have sentenced this way, now we wouldn't, we would do it differently. Clearly, people who sit in seats like yours are seeing the impact of those sentences and people coming back before you time and time again. Talk about how your experiences and some of the stuff that Hillary is talking about inform the resource-based sentencing and supervision program that you run.
Okay, well, first of all, let me just say thank you very much for inviting me. I'm honored to be here and share some of the things that we've been working on since we hit the bench in 2014. So, as a woman of color, mass incarceration insults me on a personal level, right? And so when I first was appointed and then later won the election, the first order of business for me was to figure out how would I do this job without feeding the beast that is mass incarceration. I knew from the beginning what I wasn't going to do, but I didn't quite know what I was going to do. And so in order to do that, the first thing I had to do was examine what is it about the system that is done on a systemic basis that maintains a system of mass incarceration. And after examination, it kind of became really clear to me what it was, right? You have to examine the general path that most defendants once convicted go through, right? Whether they've pled guilty or whether they've been found guilty by a judge or a jury, they have to face a sentencing judge, right? And when they face a sentencing judge, typically, except for diversion programs and specialty courts, which are a different beast, which is a longer story, but so I'll kind of bring it into to the path that I'm speaking of. But the general path is that they face a sentencing judge. And when they face that sentencing judge, generally speaking, that judge will sentence them either to probation and off to a probation officer they go, or incarceration and off to a probation officer they go. 97% or so get out and off to a parole officer they go. And after their incarceral period, sometimes they also go to a probation officer. And the very next time that the judge who sentenced that person sees them, typically is when a probation or parole officer is so frustrated that they opine revocation, or they've caught a new case and the issue is whether you lift the detainer, or they caught a new conviction. In those three circumstances, generally speaking, by the time the person sees the judge that sentenced them, it's time to punish them again. If judges only see people for punishment purposes, that, my friends, is how you maintain a system of mass incarceration. And that is also how you continue to have an ever widening trust gap between ordinary citizens and the criminal justice system, right? And so that was armed with that knowledge is what I utilized when I began to create the program called Resource-Based Sentencing and Supervision. It took me between 2014 and 2018 to actually have the program be a whole program, complete with protocols and resource networks and quick starts for judges, so that there's a very seamless transition for judges who wish to utilize a resource-based sentencing and supervision. So I guess the question would be, well, what exactly is resource-based sentencing and supervision? And what it is a system of accountability whereby the sentencing and supervising judge has an obligation to pronounce a comprehensive sentence. So for example, if I'm sentencing a young man or a young woman with 2 possession with intent to deliver in a 10th grade education, I can set my watch to their 3rd. It's time for us to stop acting like we don't know this, right? So the judge will be accountable to articulate a comprehensive sentence, and for every condition of that comprehensive sentence, provide a cost-free resource that allows the defendant to meet that condition, and critically thereafter, they must check on them. You can't give people a bunch of resources and tell them to go do better, because if they could, they wouldn't be in front of you in the first place, right? Additionally, what happens typically when defendants come back in front of their sentencing judge only since the last time they were sentenced, and they're faced with what do we do now? The reason why the answer is generally punishment is because there's no relationship between the defendant and the judge who's supervising them. Instead, they look at the supervision summary and they say to themselves, well, I haven't seen this person since I sentenced them, and probation sees them regularly, so I guess I'll just follow their recommendations. In doing that, by practice, the judge is now abdicating their authority as the steward of the sentence that they have pronounced. And so this does several things by making sure that they are coming back and charting what kind of progress they are or are not making. They could be not making progress because of personal challenges. They could not be making progress because maybe the resource is not a good fit and it needs to be shifted to another resource. So the subsequent status listings are essential. You're holding the defendants responsible for actually reimagining their life. What if I didn't have these offenses? What if my background wasn't filled with things that led me to offenses? So they have to reimagine their lives, and you have to give them the tools with which to imagine their lives. It's quite frustrating for folks to hear pull yourself up by the bootstraps, knowing full well they have no boots. So resource-based sentencing and supervision is in the business of passing out boots, but making people pull them up. And so from 2014 to 2018, we created this program, i.e. figuring out where the resource network would come from, what are the protocols, how are the quick starts. So we created that actual binder, and quite frankly, we didn't even have a name for the program until the end of 2017 to early 2018 as resource-based sentencing and supervision. So now from 2018 to 2020, we actually saw it transform people's lives right in front of my eyes. I've had countless parents in the back of the courtroom with tears in their eyes thanking me for the transformations they've seen in their loved ones. I've had defendants tell me this is the longest they've been sober. This is the longest they had a job. This is the longest they've been out of jail. I mean, so the transformations were real. And so by about 2020, I got a deflated feeling. And one would be like, well, what were you deflated about seeing your program work? The deflated feeling came from understanding my place in the sun, because I actually stumbled upon the blueprint for how one could move the needle on mass incarceration and shrink that trust gap between ordinary citizens and the criminal justice system. Deflated feeling came from knowing that I was one of 20 or 30 judges in the First Judicial District of Philadelphia, Pennsylvania, which is Philadelphia. And Philadelphia is one of about 200 judicial districts in one state that doesn't include the federal system. So the deflated feeling came from, I could run this program till I'm blue in the face and not have a single opportunity of moving the needle on mass incarceration or shrinking that trust gap between ordinary citizens and the criminal justice system. And so around 2020, from 2020 to September 13th of 2022, we went about the business of trying to create an entity that can act as the logistical support for resource-based sentencing and supervision, to be that mechanism by which this program can be equally duplicatable in any criminal courtroom, state or federal. And we finally were able to come up with it with very accomplished board members such as City Councilman Isaiah Thomas, and we got a couple of Yale and Harvard boys on there trying to work on getting our empirical data where it needs to be. That's not quite there yet, but we're working on that. And we also have Ms. Asada Thomas, who is a board member, but she is also the Director of Reentry Resources, and she is at the helm of our Reentry Resource Network maintenance and creation team, so that this can be equally duplicatable. And so in February of this year, we received our nonprofit status for the Sentencing Foundation, which is the logistical support for resource-based sentencing and supervision. And today, we are currently operating in Philadelphia with a lot of my colleagues. There's some of my colleagues dabble in the use of resource-based sentencing and supervision, but those that are staunch advocates and utilize it daily are Judge Banjais Roman, Judge KU, Judge Tamika Washington, myself, and then again, there's a few of them that dabble in the use of the program. And it is currently operating not just here in Philadelphia, it's actually operating as of about 2 months ago in Austin, Texas. Our anchor judge, Judge Hernandez, well, she's the anchor judge for Texas. Judge Hernandez and two other judges, Judges Brown, Judge Needle, operate that in Austin, Texas. And we currently are now with 3 judges in Houston that are waiting for their binder, 2 judges in San Antonio that are waiting for their binder, 2 judges in Memphis, Tennessee that are waiting for their binder, 1 judge in New Rochelle, New York that is waiting for his binder, 2 judges in Fargo, North Dakota that are waiting for their binders, and 2 judges in Atlanta, Georgia that are currently waiting for their binders. So currently, by the end of January, we expect to be in 8 to 10 locations with almost 20 judges. And of course, any like-minded judges that are listening to this transmission, or anybody listening to this transmission that knows of any like-minded judges that are interested in getting involved, you can either go to sentencingfoundation.org and we will reach out to you within 24 hours, or I believe my Chamber's number is in the chat. We welcome anybody who is interested in learning more about how that program can be run in your jurisdiction.
Wow. So I guess many things come to mind. First of all, your phone number is in the chat and has been sent out to everybody. Second of all, while you were talking about the parole and probation things, I was struck by, of course, Ronald, you know this, that exonerees don't even get that support. And so trying to help reacclimate folks who have gone through the experiences that you went through, and as you said, there are thousands of them around the country and more every day, need that plus, right? And so the other thing that I guess I was thinking about, Judge, while you were talking is how impressive it is that you bounced back from your feelings of malaise to now have all these other judges doing it. But even so, I'm stuck. The parable of the young boy and his father walking down the beach and seeing all the starfish that have washed up, and the young boy starting to throw them back, and the dad says, "You can't save all these starfish. It doesn't matter to all these starfish." And he says, "Well, it matters to this one." The way this gets done is one person at a time, and so thank you for taking the time to build it and to be continuously improving it. So John, let me turn to you because you're, now it's like, okay, here's all this stuff. You're the prosecutor. Make it happen. And I know you have a new statute in Minnesota that's just come into play. So how do you take all of this knowledge, all of these thoughts and experiences, and transform the role of the prosecutors in your office and hopefully elsewhere? You're still on mute, John.
Whoops. John, thank you so much for, first of all, the opportunity to be a part of this conversation, because this conversation is so important. And the question that you just asked, I think, is a really fundamental one about how do we make this change to go away from our mass incarceration system? How do we get to a different place? And I think we have to first answer that question with understanding how we came to be. The people that work in systems, who are prosecutors, who are judges, who are corrections officials, the police officers, the public defenders, we came to our jobs and we inherited a system that was designed a long time ago. But truly, the system that we have today, it was designed to do exactly what it's doing. It's intending to do what it's exactly doing. And our system, we have to recognize that it is a system by which we progress people lawfully towards black marks on your forehead, which are convictions, and to put people in prison, into cages. In many ways, we have accepted that system, and a part of that, there's good there. I do think we should have trials in America if we're going to convict somebody. But the truth is that trials just simply don't happen. In less than 2% of all of the cases, we have a jury trial. And everything else, it's a system of processing. And the prosecutor has a really critical role in that place where we process these situations, but they're human beings. And for too long, I think prosecutors have defined their job to do right by victims, which certainly is a big part of it. But another big part of it is to represent our community, which also accuse people who stand accused of crimes and who are convicted. And in that role of case processing, the types of things that get prioritized are things like finality. Like if we went through all that work, we had a plea bargaining or trial or whatever, we got this conviction, we got this sentence, and as Ronald found out, we do everything at all costs to protect that final decision. It's like a thing that's frozen in time, but nothing ever really changed for the betterment, I think, of the person that was harmed during that time period, the person that we sent off somewhere. And for a lot of the people in the system, it's kind of like I've done my job, I'm moving on. And as Hillary said, it's like somebody else's job. And we're not going to change any of this until we can fundamentally change our thinking, not just as human beings in the system, but as a society, to recognize that the values that we hold dear and near as human beings and in our communities and our places of worship, we do value things like mercy and redemption and reconciliation. And we got to bring those values into the criminal justice system. We have to recognize that we have to be more dynamic. We can't be static. Justice isn't something that's frozen or put into concrete and somehow we can never look at it again. Truly, if prosecutors say to themselves that it's not my responsibility to be thinking about what happens to this person once they are sent to the correctional system, that we don't care about reentry, we don't care about revisiting sentences or convictions, then truly what we are ministers of just locking them up and throwing away the key. And I would submit that a prosecutor's job and its role is to be a minister of justice and to seek justice at all times. And so this effort that's happening across the country, and it's great to hear that Hillary was inspired by the Quattrone Center. I was inspired by Hillary in hearing her speak about her journey as a prosecutor and coming to this place that we need to be thinking about mercy and redemption and reconciliation and thinking about the people that are in prison, the human beings, and thinking about whether or not we could have people released, or that we maybe need to think about things differently because we think about things differently today and apply today's values as opposed to yesterday's values. And so it's been a great journey to work with for the people to get legislation passed in the state of Minnesota, because before in Minnesota, and I think for lots of other places around the country, there is no real clear path. We have been doing this work prior to the law, but it was really under the radar, agreements with defense attorneys and trying to figure out ways. Oftentimes we would use it to mitigate collateral consequences of people that have already been sentenced. We might try to re-sentence somebody again or try to bring that case back up so that people would not be removed from this country. All of these essential collateral consequences, there have been attempts in Minnesota to try to, re-sentence people, but unless it's an illegal sentence, we didn't have that clear path. So with the prosecutor-initiated resentencing law, it couldn't be more clear. The judge is always going to make the final decision, but it puts the prosecutor in that role to say, you can't say you don't have a role anymore, because here's your path if you want to take this up. And I know that there are people in prison in Minnesota that certainly they deserve a second look. And so I'm so glad that we're going to have this clear process that we can utilize. By the way, we are also in Ramsey County, and I'm really proud of this. We, since 2012, every year we have reduced the numbers of people that have been sent to prison. So from 2012 to 2022, we have reduced that number by 67% on an annual basis. In 2023, there's going to be a little bit of an uptick just because we had to catch up from some of the things that happened during the pandemic. But Judge, there can be jurisdictions that can have less reliance on prison and incarceration. And I think it starts with, and John, you started the question, is how do we make this change? I could come up with all the policies in the world, but at the end of the day, culture will eat policy for lunch anytime. What it means is that the people in my community and the people in the system, we just need to start thinking differently. As a society, we need to embrace some of those values. We need to see more prosecutors doing press releases on the fact that they exhibited their mercy instead of getting a life sentence or something of that sort. We are on the right path, and I'm hopeful that people who are listening to this will take this up in their own communities and provide more clear pathways for the people in the system to embrace this type of work and this thinking. And I think when we do that, we will get to a place where we have more public safety, because I will tell you that in Ramsey County, I don't believe that we are any less safe than anywhere else, even despite the fact that we have used prison less than other places.
Yeah, thank you. I think that's fascinating and empowering. And let me go back to, I guess, you've sort of implemented some of these policies, and now you have a statute, right? And now you have a path forward. And Hillary, your work is working on giving more states that pathway, but also working with people to take the tools that they have in their existing statutory structures, like Judge Sawyer has, and hopefully creating experiences so that when people come back out of prison, they have the success that Ronald has had. And so I'm going to kind of open this up to each of you, but maybe Hillary, you could get us started on who should be the steward of this process, and what do we do if we don't have a statute in our state? And to each of you, how do we get those results if we're not in one of the states where Hillary and John have had a legislative victory?
Well, I mean, this all began, even as John said, without a law on the books. There was a desire to seek change and bring change and use his platform and use his position of power to do the right thing. And so, I mean, it really, I know that's maybe oversimplified, but any prosecutor across the country, whether you're elected or you're a line staff, you've prosecuted a case that you think about, and that if you prosecuted a case in your early years, you were trying to move up the ranks, and you thought you were a hammer and everybody was a nail. And so many prosecutors agree, right? And I myself agree that there were cases that we even prosecuted that we think, geez, that was a lengthy sentence, and I wonder how that person is doing. And I'm prosecuting a case 10 years later with the same facts, and I'm not asking for anything as severe as what I did in that person's case. So I think it really is just to embrace the idea that the system is not going to collapse if you are willing to accept that there have been mistakes and that people change, and that there is, as John said, that there is a role of mercy that people deserve, and they can change, and to view people as static and they're their worst mistake. It doesn't actually make us safer. It actually casts people away. And when we ask the court to send somebody away for a certain period of time, we're doing it because we believe that that's the amount of time that they're going to need to rehabilitate. So to give people a sentence that has no hope at the end of it, it doesn't really make any of us safer. And so I think that if you're in a state, so it's Washington State, it's California, it's Oregon, it's Illinois, and now Minnesota, that have these more traditional prosecutor-initiated resentencing laws, there are still many offices just in those states alone that haven't taken advantage of this law. Questions about whether the court will be in agreement, what will victims say, what about checks and balances, what about public safety? And we found that with education, people come around to see that this is actually making us safer. So in those states, we need prosecutors to ask about how to use the law that they already have. And then in other states, there are so many other mechanisms, motions for a new trial, motions for extraordinary relief. And then there are states that have, as John said, very, very, very limited means to get cases back to court. So I would say that any prosecutor that's listening, any elected, even judges that are listening, right? Judge Sawyer and I are both making this kind of call to action for everybody to roll their sleeves up and figure out where they can fit in, they can reach out to us and we can look at their penal code and we can figure out if there is a mechanism on the books. And if not, as I mentioned, the law is now in 5 states, but the law has been proposed in 5 other states. So if there isn't something that is accessible, we also work with lawmakers and also electeds, like we did with County Attorney John Choi, to get laws passed, to get a mechanism that does give prosecutors this ability. So there's a lot of ways to do this. What we need most of all is the will to lean in, for people to roll up their sleeves and feel the obligation that all of us on this panel feel, which is we have a job to do, and it is our obligation to right the wrongs. And if we have a platform and we have power, we need to do something with it.
Let me chime in there, because I've been chomping at the bit for a couple of things that I wanted to say. First thing is the public safety issue, right? From my view, mass incarceration is responsible for a lot of the off the hook violence that we now see in Philadelphia, right? When you think about the proliferation of mass incarcerations in the 80s and 90s, what that translates to and what that means is that there are generations that raised themselves because their parents were not around, right? What that means is that you take somebody who's been in jail for 5 years or 10 years or 2 years or 3 years or whatever, right? You take everything from a person, including their dignity, right? Where they have this hopelessness that they don't care about their own life. And then you open the door and think when they come out, they're going to care about your life? Absolutely not. Between the trauma and the desperation, a lot of these crimes are born from those things. So mass incarceration, in fact, in my view, is responsible for the off the hook kind of crimes that we have, right? You give people a stake in their community, right? You give them something where they can look in the mirror and actually be proud of themselves. Then they have a stake in their community, and then they have something to lose, right? Because my mother's always told me, people with nothing to lose are the most dangerous people around. You give them something that they want to hold on to. If they have nothing to hold on to, as I've said this a million times, you open the gate after so many years of incarceration, and you say, okay, go do better now. With no resources, with no way of doing that, with no understanding of how to do that. Well, what do you think that they're going to do? Folks are not going to just conveniently sit in the corner and die because they don't have what they need to survive. No, they're not going to watch folks eat steak. They're going to cut your throat and take that steak, right? They're not going to walk 20 miles from point A to B. No, they're going to take your car. So if people say, oh, I'm not interested in helping folks reimagine their lives, then stop complaining about crime, because that I don't give a crap about the next man or next woman leads to the crime that you say you want to stop. That's one thing. The second thing I wanted to say, and I'll try to pass it off to somebody else. The second thing I want to say, as it relates to a resource-based sentencing and supervision, I need you folks to understand public safety is the first question that a good judge should ask themselves. They see the offense gravity score, the prior record score, the sentencing guidelines say thus, and then you have to say to yourself, is this person a legitimate public safety hazard, right? Because in my view, 7 to 10% are so broken that they're only going to wreak havoc on the rest of us. And for them, you're going to jail, right? I sentenced somebody recently to 15 to 30 years in jail, but he was a serial child molester. And I looked him in the face and I said, sir, I don't have a program for you. You're going to jail, right? And so when it comes to public safety issues, if 7 to 10%, or some might say as much as 15%, I'll take the larger number. If 15% are so broken, they're only going to wreak havoc on the rest of us, and legitimate public safety issues require long periods of incarceration, all I hear is 85% need resource-based sentencing and supervision.
Well, thank you, Judge, and I do think it's important to say that there are, part of the premise here, I think, is individualized sentencing and revisiting in an individualized way as well, principled but individualized. And you know, I think it's interesting to think about how just that is a conferral of dignity that people can use to begin to build back. And Ronald, you know, talk about how you use the voices of people with lived experience to create that network for people to come back to, so that there is that, you know, that's another version of resource-based sentencing is what I hear, right? So maybe talk about how that works and the benefits we're able to do, and then we'll see if we can answer a couple of questions from the audience.
Sure, absolutely. John Choi made a foundational statement on which we should build all these efforts that we're doing. He said it's going to take a fundamental change in thinking. A fundamental change in thinking. And at Just Leadership, we operate from the premise of those closer to the problem being closer to the solution, but furthest away from resources, power, and opportunity to effectuate change in their communities. So bringing the voice of people with lived experience of the criminal legal system into this conversation will take you light years ahead of where you are now as far as this whole notion of reform and providing resources to the community. Because the people with lived experience, they are a resource. They're a resource from the community. And their lived experience gives them a vision that book knowledge will never give you. And so to invite them to that table to have this conversation, I think is real instrumental for us to be able to see the change that we seek in criminal justice reform. And to that end, we've had at Just Leadership, we've had the opportunity and the good fortune to be able to partner with, build what I call non-traditional, build coalitions with non-traditional allies. And the perfect example of that, the APA, the Association of Prosecuting Attorneys. We partnered with them a year or so ago around a national convening around racial equity in prosecutors' offices. And we are in the process, we wrote a white paper around it. We're in the process of doing an implementation guide on how to increase racial equity around the country and how prosecutors engage the community and engage the people they charge. So I am really encouraged to be a part of this conversation and see as many prosecutors interested, and judges for that matter, because like I said, non-traditional partnerships. If all we do is sit back and talk with each other and stand our different silos and different corners, we're going to continue to get what we've always gotten, which is basically nothing. So when we come together and provide each other our own individual expertise of what we bring to the table, now we can move the needle forward in a responsible way. We have accountability on the side of the crime being committed, and we have healing harms in the community on both sides of the coin. The person that committed the crime and the person that suffered the crime are both attended to, and then healed, their harms are healed as well. And so I think if we bring these non-traditional partnerships together, change our foundational way of thinking, that we will definitely be where we need to be.
Thank you. That's both helpful and inspiring. So I'm gonna inject the second word for CLE into what we're doing now, just to interrupt the flow of the conversation because we were getting really good. And that second word is sentencing. Sentencing is the word. So if you're thinking about the words together, it's improving sentencing. You see what we did there? And then we've got about 8 minutes left, so I'd like to maybe take a couple of questions that we've received from people who have been paying attention and watching online. I will note the comment, "This judge is so on point." That's more of a statement and observation, but I thought worth sharing. Two quick questions that maybe we can dispense of relatively quickly. The first one is there any activity to apply the sort of revisiting sentencing from the prosecutorial perspective at the federal level? And the second question is, as we talk about the different parts of the system that need to intersect, what is the role of parole boards as we are implementing some of these revised sentencings? Should they be one of the potential stewards of the sentence as well? And I'll just throw that open to the group.
I'll speak to the parole board piece of it because I work with a lot of incarcerated people, formerly incarcerated people, and I've talked to a number of parole board members around the country, and they should certainly be part of the conversation because oftentimes different parole systems. Some parole systems are appointed by the director and the governor. Others are elected civil servants. So it depends on the type of system you have. And in the ones where they're appointees, political appointees, they're a little more problematic because they get their marching orders from the governor and from their boss. And so if they say don't release nobody, then they're not going to release anybody. Michigan is a perfect example of that. back during the 90s, there was a parole board released somebody that did a heinous crime, and then the governor changed the whole parole board system and made them all appointee, and they stopped releasing people. You had to serve 125% of your sentence before you even considered to be released in Michigan at that time. And it resulted in these huge overpopulation numbers. So certainly, yes, the parole board should be part of this conversation.
Yeah, I just want to add one thing that Ronald said too, is that in this whole notion that we're case processors and we are siloed, I've heard way too much that, like, from other colleagues who are prosecutors who say, well, don't we already have a process for that? Or isn't that the job of somebody else? Why does it have to be our job? And I think that what will serve justice the best is having multiple avenues by which we can seek in just reconsiderations of things. And so that's a complex, thing about how to make that all happen, but just having more is better. It's not a exclusive thing where you can only have one thing. I think many pieces can go together.
And Hillary, thoughts about the federal level and what's happening there?
Yeah, I was just going to add, I mean, it kind of just, it's a perfect dovetail to what John was just saying, that we need all prosecutors to have this ability. And so at the federal level, they don't have the ability to advance cases. There are statutes that, there are laws that allow cases to come back to the court, petitioner-led laws, but there isn't actually a mechanism where a U.S. attorney and AUSA could actually bring a case back to court. So those are definitely conversations that we are in, because as I mentioned, we believe that prosecutors need this tool, and there needs to be several ways to get these cases back to court.
But there's nothing sort of structural that would be a barrier to this happening and being as useful at the federal level as it is at the state level.
Nope, no barriers.
Okay, so we have another question. This one's for you, directed to you, Hillary. It says, we're a Black-led women grassroots organization working to get aging prisoners out of prison in Maryland, Pennsylvania, California, and other states. It takes a lot of resources, energies, and money in this legal advocacy process because of the many decades that aging prisoners are in prison and the systemic generational trauma and poverty of Black families due to mass incarceration, which certainly the judge spoke eloquently about. Can you speak to the role of abolition and transitional justice in this era of generational incarceration?
Yeah, thank you for that question. And I also just want to reiterate that please reach out to us. I would love to have follow-up conversation about your work. We have not seen the numbers bear out with women who have been able to, be able to be released from prison under this resentencing work. So it's a big issue that we're trying to take on, and we'd love to talk to some other partners in the field about that. I think that one of the things, one of the challenges, I guess, that we have heard is, how do you marry an abolition framework with something that we do, which is, by definition, it is incremental, right? We are having to, it is the example that you gave about the starfish, right? That it's one at a time, and it is making changes within the system versus kind of an abolition framework of immediately tearing it all down. And I think that we all agree, I certainly agree, that I want to live in a world where prisons aren't necessary, where there are resources for any type of person that comes before the court, right? That we don't have to send anybody to jail, irrespective of the crime that they've committed, because there are resources in place. But we take the practical approach that we want to live in a world like that, but we simply are not there yet. And so we hope that our work, while it is incremental, can serve as a lever and a resource for people that are in the abolition, work specifically, that they can use what we're doing and build on what we're doing. But it is, I don't want to mince words and say that this isn't something that's incremental. What I will say, though, is that in the beginning, when we started this work, a lot of prosecutors, they begin this work with cases that they feel are, kind of the most compelling. So it's people who are in the older prison population, so in their 60s, people who were really young at the time, so 14-year-olds that committed their offense. because the data and the science is so strong about recidivism and also about the adolescent brain that's been an area that prosecutors have focused on. But what I will say is that, there was concerns about that this was, setting a unintentional ceiling, that those would be the only kinds of cases that prosecutors would look at or courts would look at. And today there have been about 1,000 people that have been resentenced because a prosecutor has brought a case back to court. And what we have seen over time is that while a lot of prosecutors begin with cases that fall within these categories, over time they have begun to look more at the person than at the category, right? As was mentioned, they look at what resources are available, what work have they done, and they really move away from, is this crime something I want to look at, into, can this person be safely released? So while it's incremental, we are trying to move in the same direction where I think abolitionists want us all to go. So that's kind of how we sort of internally reconcile kind of those two approaches.
Thank you, Hillary. That's great. And I think, I'm struck by how each of your approaches are taking a systematic view to individualizing the outcomes in our criminal justice system and to supporting the individual needs of people, which aren't the same, even as they get processed through our system in that sort of standardized way. We could talk about this for many more hours, and I wish we would, perhaps at a future Quattrone Center symposium, but we are at the end of our hour. If you're taking this for CLE, improving and sentencing are your two words. Judge, Hillary, Ronald, John, thank you so much for sharing your wisdom and your experience with us and with everybody else on this. This will be posted on YouTube and can be shared moving forward. And we're so grateful for your time and look forward to continuing to elevate these ideas and get them out into the world. So thank you so much. Have a great afternoon.
Thanks for having me.
Happy holiday, everybody.
Happy holidays.